Hello, everyone. Thank you for tuning in today. Um, we are in the situation of making some predictions about what is about to happen without really knowing who's at the agencies. But I think there are some indications that enable us to set out some themes about what we believe are reasonable predictions for the future and things that the audience and that the listeners here ought to keep in mind. So historically, there's been a lot of continuity from administration to administration in antitrust. Elections do matter, but the theme has always been continuity from Clinton to Bush, et cetera. And that may well be the case, and probably in some areas will be. But there is reason to believe that there may be more change happening here. And to do that, I want to give some context, which will be a context for our whole program. And the context is actually the unique state in which we find antitrust today. Historically, there was a book written by almost Justice Bork back in the late 70s. I think it was 78 or 79, called The Antitrust Paradox, in which Bork forcefully argued that antitrust was a doctrine without a rationale or without any rigor. And he kicked off years and years and years of the courts putting economic orthodoxy of the day, which generally was based on the Chicago school, into the antitrust laws. And that's certainly been the theme during my career. What has happened, I would say, in the last 3 or 4 years is there's a different literature coming out. There are book after book after book, and I was just reading a book by a gentleman named Philippon called How the United States Gave Up on Free Markets. And the theme is that we gave up on antitrust, but the EU didn't. But you could fill at least one shelf of your book area with books talking about antitrust having failed over this period, that there is a major concentration problem in the United States, and that antitrust has been hamstrung by the laws under which we operate. I think that there is a new book, interestingly, called The Antitrust Paradigm. And for those who I think want to predict what's going to happen in the Biden administration, I kind of think that this is mandatory reading. It's by John Baker, who is former FTC head of the Bureau of Economics. He's a lawyer and an economist, a professor at several law schools, who now is mostly doing consulting and writing. And he, in this book, goes through areas that he believes the antitrust laws have failed. He presents a case that there is a concentration problem in the United States. And he talks about the need for pushing the boundaries of antitrust in court, and the need perhaps for legislation. Why is this important? Well, the answer is that as far as we can see, and we at Gibson follow this closely, there's a lot of sentiment in that favor among the victorious Democrats and among the transition team. For example, at the FTC, one of the main people involved is Bill Baer, former Arnold Porter partner, now at Brookings. And he gave a speech to the ABA in the fall forum along the lines of what I just said, along the lines of what John Baker of what this literature is saying, that the courts have made it too tough on the government to win cases, too tough on plaintiffs to win cases, and that there needs to be, again, legislative change. And that's the first topic we're going to discuss today. Rachel's about to do that. And there needs to be aggressive enforcement pushing the boundaries. All of this is in the context of, in my opinion, I always thought and I always said that the Obama term was about as vigorous enforcement as I've ever seen. And it's not like the agencies weren't winning cases. I think they once went 13-0 in merger cases. But the narrative is that the law is such that the agencies have to pass on tough cases and enter into settlements where they shouldn't. And so we have this problem in the United States, the concentration problem. It's obvious everybody talks every day about the platforms, the quote unquote platforms. But I think that this, the new school of Democrats are also talking about phenomena in the airline industry, in agriculture, and healthcare, and other industries. So the concern is across the board. And that is where the transition team, and while we do not know who the new officials are, one could reasonably predict that they are going to have a charge of stepping up enforcement. And one could really reasonably predict, particularly after Georgia and other events, that that there will be a legislation, or at least a serious attempt to get legislation passed. What do we know now? Well, we don't know anything about who's going to head the FTC. On the DOJ side, obviously, we know Judge Garland, who, by the way, and I didn't know this till I started getting ready for this program, once was an antitrust professor adjunct at Harvard, always been interested in the area. And the other three, Ms. Gupta, Ms. Clark, and Ms. Monaco, are really not antitrusters. Ms. Monaco, the number 2 at DOJ, has a strong national security prosecutorial background. Ms. Gupta and Ms. Clark are both civil rights lawyers. So you can see the immediate priority of the Biden folks. But with that as an introduction and as kind of context for what we're saying, let me turn this over to Rachel to talk about potential developments on the Hill.
Yeah, I'm going to start by talking about things on the Hill by talking about the courts. And while that might be somewhat counterintuitive, as Rich was saying, we can expect the Biden administration to be seeking to push the boundaries of competition and antitrust law in the courts. But there in the courts, they will face something of an obstacle, which is a judiciary, especially at the courts of appeals and Supreme Court level, that is much more steeped in the Chicago school and coming out of the world of Bork than it is in the increasingly prevalent, more agenda-pushing area of antitrust. So while we can certainly expect this administration to file lawsuits that seek to push the boundaries, those who are setting the antitrust and competition agenda in this administration are very much aware that to achieve what they really would like to see, outside of the antitrust laws, but in the economy as a whole, and using the antitrust laws as a tool, that legislation is also required. In terms of legislation, we know that those efforts will be led in the House and in the Senate by Representative Ciccolini and Senator Klobuchar. And each of them is both experienced and aggressive in thinking about the scale and scope of antitrust enforcement. As in so many other areas of the law, the Democratic control of the Senate portends significant efforts to change, or as they would say, modernize the antitrust laws. Changes of a scope and scale that are unprecedented for nearly a century. But the lines of leadership are clear, as are the policy agendas that each has. Representative Ciccolini oversaw the House report on the digital economy, and the conclusions there we can expect to influence legislation. He was very clear in saying he would not propose legislation until his report was released. And those proposals are broad in scope. They include suggestions like banning digital, and again, we'll put in quotes, platforms from acquiring rivals or potential rivals, legislating digital marketplaces and forbidding those who operate digital marketplaces from also selling on those digital marketplaces, and also expanding, for example, the regulations on those who choose to serve in government roles and preventing those who take on senior positions in agencies like the Department of Justice, the Antitrust Division, and the Federal Trade Commission from representing clients before those agencies at all following their service, as opposed to sort of in the active roles currently encompassed by legislation. So really aggressively seeking to address what they view as revolving door conflicts of interest on the counsel side. Turning to Senator Klobuchar, Senator Klobuchar, unlike Representative Ciccolini, has been aggressive already in proposing antitrust legislation. She proposed more than 5 bills in 2020 alone, and we can expect that trend to continue. And several of those bills had bipartisan support. They had co-signers from the Republican Party, even when the Republicans controlled the Senate. And there is little reason to believe that will change. While the view on what should happen in the antitrust laws certainly isn't agreed across the board, this is not strictly a Democratic issue. And we can expect Senator Klobuchar to continue to talk with her counterparts and to seek support for her legislative agenda. Those include statutes that we can expect to see looking like those she's proposed before, like the Monopolization Deterrence Act, which she proposed in August 2020, which would authorize the DOJ and FTC to impose civil penalties in connection with monopolization or dominance investigations. In June of 2020, she and Senator Grassley, a Republican from Iowa, proposed the Merger Filing Fee Modernization Act, which would significantly increase the fees for mergers, particularly for already large companies, and set up a much broader differential that seeks more to shift the cost of investigating mergers by large companies to those large companies. She also proposed the Consolidation Prevention and Competition Promotion Act, which would expand the antitrust laws in terms of their authority to regulate monopsony power, which is buying power, and impose much harsher thresholds on what she deems mega mergers. There's the Merger Enforcement Improvement Act, the Anti-Competitive Exclusionary Conduct Prevention Act, and other proposed legislation, all of which would seek to do things like shifting to companies with more than 50% market share the burden of proof in cases, as opposed to having the initial burden of proof with plaintiffs, reducing the burden of proof for plaintiffs on various Section 2 monopolization claims, including for certain claims the obligation to prove a market definition, eviscerating many existing implied immunities, and so forth. And just this week, Senator Klobuchar announced that she'll have a book coming out in March called Antitrust: Taking on Monopoly Power from the Gilded Age to the from the Gilded Age to the Digital Age, which she has termed a, quote, call to action, close quote, to address corporate consolidation, dark money, and rising income inequality through a pro-competitive agenda. And of course, Senator Klobuchar, we know, has allies on these issues, from just her fellow presidential candidate, Senator Warren, Senator Booker, and others. And, you know, it is also, you know, well known that she was one of the early people to abandon her campaign and endorse President-elect Biden. And this is an issue very near and dear to her heart. So we can expect her to be pushing aggressively these areas of change. Next
Rachel, let
slide,
me,
please, Shaylee.
I'm sorry, go ahead.
Oh, sorry,
yeah.
no, please chime in, Rich.
Yeah, I was just going to say, and I've done this a lot, litigated against the government in merger challenges. It's already tough enough. But I think what one of the bills would be is that the burden is now on the defense to justify the merger, as opposed to the government getting a presumption with certain market shares and then having to explain how a bad effect is going to occur. Somehow the defense is supposed to prove a negative, that nothing bad will happen. Let's just say that will be a challenge, and a bill like that would materially change the way merger enforcement, for example, has happened over the last 20 or 30 years.
Thanks, Rich. Finally, on the legislative front, I think we can also expect to see push for bigger budgets, both at the Antitrust Division and at the Federal Trade Commission. They are both widely viewed as underfunded on the Democratic side. And the incoming chair of the Senate Budget Committee, Senator Bernie Sanders, is unlikely to oppose expanding budgets in these areas, including for the FTC's consumer protection mandate. The FTC's Bureau of Consumer Protection currently has fewer attorneys in it than does the California Attorney General's Office's Consumer Protection Bureau alone. Just one state has more attorneys doing this work than at the federal FTC. I think we can expect that to change, but the budget to increase as a whole. And from that, we can both expect more of the existing enforcement, more money underwriting things like the Department of Justice's special Google task force, and also the creation and funding of additional task forces focused on these high priority litigation focused areas. With that, I will turn it to Shaylee to talk about what we expect the agencies to do with these expected expanded budgets.
Thanks, Rachel. I'll start by talking a little bit about what we expect to see at the state level, because while we have Democratic-controlled executive and legislative branches at the federal level, at the state level, Republicans still comprise the majority of state attorney generals. So the question is, what does this mean for antitrust enforcement? Well, traditionally you see Democratic AGs more active and vigorous antitrust enforcement efforts. So one might think that this will mean we'll see more coordination between the federal antitrust regulators and state regulators over the next 4 years. For example, antitrust authorities in New York and California that are traditionally very active in this area. This wasn't necessarily the case under the Trump administration. A good example of the split between federal regulators and state antitrust enforcement actions came with the T-Mobile Sprint acquisition. The T-Mobile's $26 billion acquisition of Sprint was cleared by the federal antitrust regulators, but then a coalition of state AGs led by New York and California challenged the deal. They took it all the way to trial, where of course T-Mobile and Sprint prevailed. So under the Biden administration, one might expect to see more coordination between the federal antitrust regulators and the states, as I said. In particular, we already see this playing out a bit in the big tech investigations. So in October 2020, the DOJ filed its complaint against Google. That complaint was joined by 11 state AGs, all of whom were Republican. The DOJ complaint focused on alleged that Google maintained its monopoly by entering into exclusivity agreements, tying arrangements, and other long-term agreements that foreclosed competing search engines from being able to gain vital distribution and scale. The DOJ also alleged that Google used its monopoly profits to buy preferential treatment for its search engines on devices and web browsers. That was the October 2020 complaint. Then last month, we saw another complaint filed by 35 state AGs, again, a very bipartisan coalition, pretty much evenly split between Democrats and Republicans, that contained allegations going beyond those in the DOJ's complaint. Namely, the states also alleged that Google's search results favored its own services over those of its rivals, which harmed competition, allegedly harmed competition. The state's complaint also alleges that Google used its dominant position to become the default search engine, not only in web browsers and on smartphones, but also in new technologies like smart speakers and connected cars. So the state AGs are looking to consolidate that case in federal district court in DC with the DOJ's case. Meanwhile, we also have another case against Google pending in Texas that was filed by the Texas AG and a group of 9 other Republican-led states. And the Texas lawsuit is different than the ones pending in DC. It focuses on Google's operation of its advertising exchange. And so its role as a middleman in the sale of online ads that are displayed on third-party websites. So it's an entirely different theory that's being pursued by the DOJ and the state lawsuits that are pending in federal district court in DC. And Texas has been very aggressive in leading that effort. It remains to be seen whether the DOJ will pursue a similar theory of harm against Google. The Facebook enforcement actions are also seeing coordination between the federal and state authorities. The FTC and a bipartisan group of 46 states, so nearly every state AG in the country, filed parallel lawsuits against Facebook last month. Both of those cases allege that Facebook maintained an illegal monopoly by buying up potential rivals, particularly Instagram and WhatsApp, and also allege, it engaged in anti-competitive conduct, for example, cutting off its API or application programming interfaces to quash perceived competitive threats from rival services. In response, of course, Facebook has noted that the FTC cleared its acquisitions of both Instagram and WhatsApp. Of course, the FTC and DOJ can contest transactions after they've been consummated. So that leads us a bit, I think, into our next topic, which is to focus on what do we expect merger enforcement will look like under the Biden administration. As Rich mentioned at the outset, there is a relatively widespread and growing perception, certainly within the Democratic Party, but also among some Republicans, that there's been a potentially problematic increase in market power held by large companies in certain sectors of the economy. That includes technology, but also healthcare and agriculture sectors. The DOJ under Democratic administrations has historically issued second request and litigated merger challenges at a higher rate, more frequently than under Republican administrations. And that's reflected in this graph on this slide. So for both of those reasons, both the fact that there's been this general trend, general growing sentiment that we have a concentration problem in the American economy, and the fact that the DOJs under Democratic administrations tend to be more active in this space, we expect that there'll be a higher rate of second requests and merger challenges in the next 4 years than there were under the Trump administration.
Haley, could I make a point here, going back to 2 things you said. First of all, note the Republican participation in the state cases against Facebook and Google. And so there's a lot of concern on both sides on concentration. In the merger area, and I forgot to mention it today, there is a literature that's emerging, scholarly literature that says most mergers don't achieve the efficiencies they were supposed to achieve or they aspired to achieve. And so there's always been a concern trying to reach a balance between over-regulating, and that is challenging efficient mergers, and then under-regulating, that is missing some that are anti-competitive. And I think now there's a feel that the danger of over-regulating is less real than it was previously thought, largely because of this scholarly literature about the failure of most mergers. And by the way, we are reporters here. We're not taking any views on who's right on these controversial issues. But there's no question that literature is out there, and I think those who want stronger merger enforcement are suggesting that we've spent too much time recently worried about over-regulating, and we ought to be worried a lot more about missing it anti-competitively.
Thanks, Rajay. That's definitely right. And I think, the other place where we might see more aggressive enforcement expands to the area of nascent competition. So one of the trends we might see emerge is more challenges brought in cases in which a large company is acquiring a smaller company, or even just a potential entrant into a certain space. And that's because a growing number of academics and elected officials have argued that the acquisition of these smaller potential rivals should be challenged, not based on the harm to current competition that those mergers could pose, but the harm to potential future competition. Such enforcement actions would involve relatively novel theories of potential or nascent competition, and the agencies don't have a robust history of pursuing those types of mergers. Although recently we saw the DOJ pursuing such a theory in its challenge of the Visa-Plaid merger, which the parties announced yesterday that they are abandoning. The FTC also recently sued to block Procter & Gamble's acquisition of Billy, which was a smaller razor startup company, a deal which the parties then also terminated in the face of FTC opposition. So this is a space where we might start to see more active enforcement, but there are still a lot of questions about what enforcement attention will look like in this space, namely what analytical framework the agencies might use to evaluate these kind of nascent mergers. Traditionally, agencies look at market share as evidence of market power and the potential for a merger to produce anti-competitive effects. But in a nascent competitor case, the acquired company obviously has little or no market presence, so the agencies can't rely on market shares and instead have to point to marketplace evidence establishing a real potential for anti-competitive harm. It's worth noting in this regard that the acquiring company's documents can be used against it. For example, in the Visa-Plaid case, we saw the DOJ's complaint rest heavily on internal Visa documents that the DOJ argued demonstrated that Visa viewed Plaid as a competitive threat and was seeking to acquire it as like an insurance policy to guard against that threat. So those types of documents can make what is generally seen as an uphill battle for the agencies, improving a nascent competition case maybe a little bit easier. Another place where we could potentially see increased scrutiny comes with vertical mergers. So generally speaking, vertical merger enforcement has not been a priority for the agencies under either party's leadership, under either Democratic or Republican administrations. But when the DOJ and the FTC issued their new vertical merger guidelines in 2020, they were criticized by some Democratic FTC commissioners and members of Congress for largely maintaining the existing framework for evaluating vertical mergers. Namely, some of these commentators thought that the guidelines overemphasized the benefits of vertical mergers, like Rich was kind of saying with respect to this general skepticism of mergers in general. And so it's possible that, while the career staff at the agencies will continue to follow the 2020 guidelines, it's possible that President-elect Biden's political appointees may face pressure from within the Democratic Party to investigate vertical mergers more aggressively. Finally, there might be pressure from within the Biden administration to incorporate non-traditional factors into merger review. This would be factors such as the effect that mergers might have on labor, on low-income communities, and on racial equity. Indeed, as highlighted on this slide, the 2020 Democratic platform advocated for such an approach in merger review. With respect to labor in particular, the historic view has been that job cuts resulting from a merger are indicative of efficiencies. But along with this shift towards more skepticism regarding merger efficiencies, generally speaking, as Rich touched on, we have to query whether this historical view of job cuts being indicative of efficiencies will hold. That is, will antitrust regulators continue to look at job losses arising from big mergers as favoring efficiencies, or could they start looking at those job cuts as cutting against a reason to clear a merger? So turning to conduct investigations and litigation, the big headline there obviously is the platform litigation, as we've talked about. So as previously mentioned, the fourth quarter of 2020 saw the DOJ file its lawsuit against Google and the FTC against Facebook. We obviously expect the antitrust agencies under Biden to continue to pursue these cases with all vigor. Among the antitrust community writ large, there has been a perception of the US falling behind European and other enforcers in pursuing monopolization and abusive dominance claims, as Rich talked about at the outset. So this may be a place for the Biden administration to push harder and seek to reassert the US antitrust agencies' leadership among regulators worldwide. For example, new blood at the DOJ and FTC may seek to reevaluate the Google and Facebook cases, which are still in their very early stages, to ensure that they think that those are the strongest cases that the agencies can bring. And while the Google and Facebook cases will continue to occupy a significant portion of the agency's resources, the new administration may also look to bring conduct cases in other concentrated industries. In particular, Democratic elected officials have called out healthcare, agriculture as being sectors to look at. We may also see increased scrutiny in terms of telecommunications, media, and financial services. Other big litigations that were filed in the Trump administration, but that will continue apace, include the generic drug price fixing litigation, where the DOJ is pursuing its first criminal claims against big drug companies for alleged price fixing. And then we also have the poultry price fixing litigation, which so far has netted indictments of 10 individual executives. So I'll hand it over to Rachel to talk a bit more about what we expect criminal antitrust enforcement to look like over the next 4 years.
So Richard spoke about continuity in general being a priority of the antitrust enforcers in the US, and probably in no place is that more true than in criminal enforcement. There is wide bipartisan agreement that those who engage in criminal antitrust violations, including price fixing, agreements to restrict output, customer or market allocation, those types of violations should be pursued aggressively, prosecuted criminally, and that enforcement should include not only corporate fines, but jail terms for the most culpable individuals. There are also always peaks and valleys in criminal antitrust enforcement. Much of what has driven criminal antitrust enforcement over the past 20 years is the Department of Justice's leniency program. And what the leniency program does, in short, is incentivize companies to break from their cartel conduct and self-report violations of the competition laws. Over the course of the leniency program's history, that program has netted billions of dollars in fines and years and years and years of collected prison terms. But in the past 4 to 5 years, self-reporting has unquestionably declined, especially in the context of hardcore international global cartels. The leniency program is important because it tells a company that they will face reduced fine exposure to including no fine exposure, that its executives and culpable individuals will not face prison terms, and they will be treated more fairly and without question no less generously than their co-conspirators as a general matter and in civil litigation. That's under a law called ACPARA. But in the past 5 to 6 years, there has become an increasing sentiment among the private antitrust bar and corporate counsel that those protections that have historically been part and parcel of the leniency program are not as clear and consistent as they were historically. While no doubt both Republican and Democratic administrations have questioned that critique, it is nonetheless the prevailing sentiment. And so the question that the Biden administration faces on criminal antitrust enforcement is how to rebuild trust. Setting aside whether there was an appropriate breach of trust at all, it unquestionably exists. So how do they rebuild that trust and refill the pipeline of companies that are self-reporting these very serious violations of the law? I think we can expect increased policy guidance from the Department of Justice on these issues, as well as potential legislative reforms to address some of the shortfalls of ACPARA, all of which are devoted towards increasing the number of companies that are self-reporting. Jaylee, may we see the next slide? This is just an example of sort of the fall in enforcement. It is a little misleading. 2015 saw the announcement of unprecedented number of pleas in both the areas of price fixing of auto parts and in the financial services sector. So the volume of pleas and the scope of affected commerce driving fines was extremely high. It is also not uncommon that at the time of changes in or potential changes in administration, you see sort of a looping up and wrapping up of existing investigations. You saw that at the end of the Clinton administration, at the end of the Bush administration, and then in the end days of the Obama administration as well. But you didn't see it particularly in the end of the Trump administration, other than in 2 indictments that I'll talk about in the labor antitrust space. Shaylee, can we see the next slide? And the labor antitrust space, which Shaylee talked about in the context of mergers, will unquestionably be a priority in this administration. This all started, this sort of chain of events we'll talk about, in October of 2016, specifically October 2016, when the Obama administration announced the DOJ FTC guidelines for human resources professionals. While those may have a sort of non-remarkable name, they represented a sea change in competition enforcement, because for the first time, the Department of Justice announced that it intended to prosecute employment-oriented antitrust violations as criminal matters. And they made clear that a host of other matters would be subject to increased civil enforcement. What became clear over the past 5 years and became more and more publicly known was that Vice President Biden had those guidelines as a project of particular interest to him. He was one of the driving forces behind that change. And so we know from 2016 that those issues will remain prominent and predominant in his administration. That's not surprising given the interest in income inequality, the risks of monopsony power in the employment context, and other antitrust and competition law issues that are otherwise a priority of this administration. Here too, it's not simply a partisan issue. In the Trump administration, both the DOJ and FTC held public workshops on questions at the intersection of antitrust and employment law. In September 2019, the DOJ had a workshop on labor market antitrust, looking at questions of monopsony power, whether or not employers are violating the antitrust laws or exercising undue power in collective bargaining contexts, and also looking at competition in merger enforcement connected to employment. The FTC, for its part, had a workshop on the future of non-competes and whether the FTC could or should regulate in that area, either through enforcement or rulemaking. And most recently, the Department of Justice, one in December and one in January, announced indictments of labor antitrust criminal offenses. One, an anti-competitive agreement to fix prices, and one, an alleged antitrust agreement not to hire one another's employees, or a criminal no poach or no solicitation agreement. These are notable for two reasons. One, they're both indictments, not plea agreements, which means that the Department of Justice still hasn't secured a voluntary agreement to plead guilty, or at least hasn't announced that they've secured a voluntary agreement to plead guilty for these types of labor market violations. And it means that the burden will be on the Biden administration to prove that these antitrust and employment violations are the appropriate subject of per se condemnation and criminal prosecution under the antitrust laws. But given the Vice President Biden's then role and President-elect Biden's interest in these issues, we can expect that the incoming administration will prosecute these cases vigorously. And it means we will get decisions on these critical questions of first impression at the labor and antitrust intersection. Turning to non-competes, this too is a long held area of interest for President-elect Biden. He tweeted in December of 2019 that he supported a ban on non-competes because he believes they result in wage suppression. And insiders think a ban could be yet another one of those legislative initiatives we see. Maybe it will be for all non-competes. We can expect it would at least cover non-competes below a certain income threshold. So all of those are changes that we should anticipate being part of the Biden administration's labor and antitrust priorities. Shaylee?
I'll talk a little bit about antitrust enforcement of FRAND commitments, because this has been an area of ongoing debate and partisan differences. So really the debate has been over what is the proper role of the antitrust laws in the licensing of standard essential patents that are subject to FRAND commitments that patent holders will give to a standard setting organization in order to have their patent incorporated into the standard. Now, under the Obama administration, the DOJ took the position that under appropriate circumstances, the antitrust laws do have a role in enforcing FRAND commitments. The 2013 policy statement issued by the DOJ on remedies for standard essential patents subject to FRAND commitments expressed the view that damages rather than injunctions were the appropriate remedy for the infringement of a SEP, at least in some circumstances. So this position had the effect of helping standard essential patent SEP licensees by discouraging patent owners from seeking injunctions to help to exclude licensees who violated their license terms. There's a concern that allowing for injunctive relief in those cases might lead to patent holdup and allow patent holders to exercise monopoly power. But the DOJ antitrust division under the Trump administration saw things differently. And they rescinded the 2013 policy statement and shifted to a more patent holder friendly approach. So the DOJ under Trump issued a new policy statement in 2019 that adopted the position that patent law should govern whether an injunction is an appropriate remedy, regardless of whether a standard essential patent is at issue. Assistant Attorney General Delarine publicly stated that the antitrust laws should not be used as a tool to police FRAND commitments that patent holders have made to standard-setting organizations. There was also a very public split between the federal agencies on this issue that became visible in the FTC versus Qualcomm case. There, the FTC sued Qualcomm, alleging, among other things, that it engaged in anti-competitive practices by violating its commitment to license its SEPs on FRAND terms to rival chipset manufacturers. The FTC prevailed at the district court level, and then Qualcomm appealed. On appeal, the DOJ actually intervened in Qualcomm's favor. And the Ninth Circuit reversed the FTC's win, largely adopting arguments advanced by Qualcomm and the DOJ that antitrust law had no place in policing FRAND commitments. The panel appeared persuaded, the Ninth Circuit panel appeared persuaded by arguments that contract and patent remedies are better equipped to handle FRAND disputes than antitrust laws. We expect that DOJ under the Biden administration may revert back to Obama era positions. As a result, we may see increased antitrust scrutiny of SEP patent holders and more protections for licensees in the standard setting process that takes place within standard setting organizations. So I think that wraps up the specific issues we wanted to focus on today. And it looks like we have some time for questions if there are any, or Rich and Rachel, if there are any other things you wanted to address, I welcome you guys to chime in.
Shaylee, I do think we need to read the CLE code for New York.
Oh, yes, thank you. My one job I forgot. So for all attorneys participating in this webcast, please note that the MCLE passcode is 2221. I'll say that again, 2221. And that code must be included on your MCLE form in order to submit it for credit.
Could I just sum up for a second of the takeaways from, or at least the takeaways that I think are the most important from here, is anticipate some serious legislative changes which, if enacted, would have some profound effects. Second, expect enhanced personnel, bigger budgets for expert witnesses and other related activities by these agencies. Third, I would expect invigorated merger enforcement with or without legislation. It wouldn't surprise me if the agencies change the guidelines to make it easier to get a presumption of anti-competitive conduct at a lower HHI or share level. Criminal, as Rachel said, I would certainly anticipate enhancements to the leniency program to provide greater certainty and to implement what had been the major rule of the program, which is nobody is ever worse off for self-reporting and being the first person in. I think that these agencies will want to own Section 2 worldwide, and so I would expect the agencies to look closely at the current cases they have against Facebook and Google and determine whether they want additional charges or different charges, noting that the Texas case and the state case in Washington are broader than the current DOJ case. Finally, I think that, as Rachel said, I think labor issues will be front and center. And I think you could see a change in the tendencies of the agencies on patents to support, to be more friendly or less friendly to patent holders. Those are sort of the takeaways. Rachel, what would you add to what I said in terms of sort of summing up so people can can take away the message we're conveying today.
Yeah, well, what I would say is, with all these changes, one, I think we can expect, as each new law passes litigation, not only enforcing those new laws, but around their scope, retroactivity, lawfulness. And I think as we await those legislative changes, the antitrust authorities are well known for announcing their intended enforcement perspectives through speeches, white papers, and at the FTC, opinions and statements surrounding decisions that were being made. And, in the early days and as new political appointments are made and people are confirmed, while you await decisions on actual cases or filing, it'll be important to keep an eye on those kinds of developments. Certainly, we'll issue alerts and other information about them, and you can always contact any of us to ask questions. But those are all places where I would have attention, forward facing for, how all of these ideas are going to be rolled out in practice.
Shaylee, what would you like to? What would you add by way of summation here?
I mean, I think you guys have covered it well. I think, like we've been saying, it'll be important to keep our eye out on these legislative developments, because there's only so much the agencies can do in the current paradigm, right? And particularly given the makeup of the courts, as Rachel was describing them at the outset. So it'll be important to keep our eye on what's happening on the legislative front. And then, like Rachel said, the agencies will do tend to kind of preview their policy enforcement priorities in speeches and whatnot. So I expect we'll see those coming out after we have more clarity about who will be leading the agencies under Biden.
Do we have any questions from others?
Well, great. I think we can thank everyone again for your time, and feel free to reach out to Rich, Shaylee, or me, or any of our colleagues if you have questions about this or any other news that's coming out of the Biden administration with respect to antitrust. Thank you so much.
Very much. Thank you.